have reference to it. But we have begun recording, so I'm going to start my really quick, in a nutshell, race through each of the dot points in AOS2. Please make sure that you've got a Google Doc or something else to write in open, so that you can get whatever incredible nuggets of wisdom are coming out in this quick lecture. So the first dot point is a broad one: the principles of justice, fairness, equality, and access. Basically, you need to know what they mean, but you also need to know what they mean specifically in a civil law context, okay? So we know fairness is about processes and procedures, making sure things are unbiased and fair. It's hard because there's not heaps of great synonyms for fair, for people in the justice system. So do parties get to go through pre-trial procedures? Is their dispute going to be heard by a competent and unbiased court, or some other means if they pursue alternative dispute resolution methods? Is this are the processes fair for parties? Equality does what it says on the box. That's about people having the same treatment or equal treatment irrespective of their personal characteristics, okay? So do both parties have access to the same resources? Equality and access, of course, overlap quite a bit, and equality and fairness also do as well. Access, again, this one is more about, do parties have sufficient resources to pursue their case and to find out information about their case in order to either pursue it or defend it in a way that's fair. In terms of how these link specifically to civil law, I gave you a big document explaining this in relation to the Wilson case, and that's on your masterclass document. Big hint there. Okay, now we move on to methods used to resolve civil disputes. The only methods that we really did a deep dive into were what's called alternative dispute resolution methods. Methods such as mediation, okay? That's where you have the two parties come to conduct a negotiation and the third party just facilitates. They do not suggest alternatives or solutions to the parties. They can't do that. Similarly, conciliation is a method where the parties come together, but the third party can actually suggest some or particular pathways to the parties. Both mediation and conciliation, however, do not produce a binding agreement unless the parties draw up what's called a deed of settlement, some kind of legally binding agreement together at the end of the negotiation process. Arbitration, on the other hand, is a little bit more formal. It's often used in quite technical industrial disputes because the arbitrator is often an industry professional. And the third party, the arbitrator, does make a decision that is binding on the parties. There are lots of commercial contracts that have clauses in them saying that in the event of a dispute, parties need to go to arbitration, conduct an arbitration, I should say. It's not correct to say go to arbitration because it's not a place, it's a method. All of these three things are methods. So you don't go to mediation as a location. You might do your mediation in a court, to be honest, but it's just a less formal way of resolving disputes. The other method, or the thing that we call, the word for a court resolving a dispute is judicial determination. So that's where a magistrate or a judge sitting in a court hears and determines the case. But that is not so relevant for this. Here on this dot point, we looked at those three ADR methods, and there's a really, really good PowerPoint looking at when they will and when they won't be suitable, because you need to know that. Mediation and conciliation will be great if there are ongoing relationships between the parties, but they are not good if there are really technical legal areas that are involved, or where the parties perhaps don't have an ongoing relationship or really need some kind of binding outcome into the future, okay? You might be looking more at an arbitration there, or even going to court to have it judicially resolved. All right, number 3, institutions. We looked at VCAT and CAV. The Victorian Civil Administrative Tribunal and Consumer Affairs Victoria. You need to know what they are, what their purposes are, what stuff they can hear and determine or help with, and how they achieve their purposes. Again, there is a great PowerPoint about this, but essentially VCAT is, we kind of went over it in this, in fact, in a real nutshell. If we go to our stream, this person said it all. This response is awesome. VCAT aims to provide Victorians with accessible, low-cost, efficient, independent tribunal that delivers high-quality dispute resolution. They do this by providing their services in various locations. They've got what's called a tiered fee structure, which is supposed to enhance fairness and access. And it's also very, very busy, but quite efficient. Okay. Although demand that's been placed on it in recent times has limited the efficiency somewhat. Bit of a counterpoint there. Hello. CAV, don't worry about it. In fact, an overview of the role and civil jurisdictions of the Victorian courts. Hi, you need to know, this is just rote learning. You got to know what the magistrate's court can hear as part of its original jurisdiction. It doesn't have any appellate jurisdiction. You need to know about the county court. Again, what kinds of civil disputes can it hear? Does it have any appellate jurisdiction or not? The Supreme Court Trial Division, much like the county court, has unlimited civil jurisdiction. It's got very limited appellate jurisdiction. And the Supreme Court of Appeal pretty much exclusively does what it says, hears appeals, on a range of different grounds. So please go back and review that lesson if you need to. There's a jurisdictional map. Look at it, fill it out. It's in the masterclass document too. Role of the jury in a civil trial. Okay, so while they are rarely used because the party that wants it has to foot the bill and request a jury, when they are used, there's only 6 jurors, and generally their role is to determine the liability of the defendant. Occasionally, depending on the cause of action, they can help determine the amount of damages or the remedy awarded, but that is not the case in defamation suits. Okay. Purpose of remedies. Hi, you need to know broadly the purpose of all remedies is to restore, in as far as they can, the plaintiff to the position they would have been in had the civil wrong not occurred. Okay. But underneath that, we've got damages and we've got injunctions, and you need to know their specific purposes too, because damages do that restoration by the payment of money from the defendant to the plaintiff, okay, to, restore them to their position in a financial capacity. Injunctions, their purpose is to either stop the defendant doing something or to compel the defendant to do something to remedy the harm that they've done or to prevent them from continuing to do harm into the future, okay? Again, not sure why these dot points aren't flipped around but whatevs. So then you do need to know what the types of remedies are. Damages. We looked at 3 main types of, maybe 4 main types of damages, because there are quite a lot. The key kinds of damages you really need to know are called compensatory damages. There are 3 subtypes. You've got special or specific. They refer to the same thing. Damages that are awarded for loss that you can quantify. General damages, which are awarded for things like pain and suffering, psychological illness, stuff that we can't give an explicit value to. And then what's called aggravated damages, which you can kind of tell from the term itself is to compensate the plaintiff for embarrassment or their feelings being hurt, essentially. So we looked at a bunch of other kinds of damages, but I would say they're not particularly relevant, although good to know. Injunctions, you got 2 types. You got mandatory and restrictive. Mandatory gets the defendant to do a thing. Restrictive gets them to stop doing a thing or prevents them from doing a thing. Okay, so mandatory could be, yep, you actually have to go and paint that fence that you said you were going to before my wedding, or 2 is you need to not bulldoze that heritage listed building. Okay, then we did one civil case and we did a deep dive into the Bauer and Wilson and Bauer media case. You need to know what Wilson was claiming, okay, and why. All right. Remember, her central claim was that Bauer Media, through their publication of a series of stories in Woman's Day and some other magazines, accused her of being a liar and lying about things like her age, her real name, blah, blah, blah. So you need to be across that. You need to know which court heard it in the first instance and then on appeal. All right. You need to know which method of dispute resolution was used. In this case, there's no evidence that they did a mediation, even though usually that is court ordered. So we would just say really here that judicial determination, i.e. The case being determined by a judge, was the order of the day. Remedies. I got you to look at remedies in quite a bit of detail. You need to know what special or specific damages were awarded, and the general and aggravated damages awards as well. Wilson also sought an injunction, although it's not clear whether that was in fact awarded by the court, but important to know. Bauer Media appealed the case, and on appeal, the damages, the quantum, the amount of damages awarded in the first instance was slashed from like 4.5 mil to $600,000. You need to know that. And you need to be able to talk about the extent to which the podge were or could have been achieved in this case. I spoke about that at length yesterday, but it is important that you know that because these are two well-resourced, famous, big players, it's very different to what justice looks like for your average punter, okay? But you need to be able to go through fairness, equality, access, and pick out some key aspects of these and how they were in fact achieved in the case. The key counterpoint in this case, if you're answering a discuss or an extent to which question, is that Rebel Wilson's enormous celebrity, okay, is perhaps something that could influence the jurors or kind of jeopardize their integrity, I suppose, in the case. But that's about it. You got to make sure that you can do these skills too. They all connect to the dot points, and I've built them into the lessons for you. I don't want to speak anymore though, because it's 2:46. That's the end of my speed run through this outcome. Thanks for coming to my TED Talk. And I'm stopping the recording now, I hope, but I don't know how to. Oh, here we go. Cool. Are there any